For the appellant, please, Lord. In fact, on the last occasion, Lord, after hearing on this application IF4/2022, which was filed for recalling, Lord, your Lordship had indicated that it would be better fit if I filed a review. Lord, review is filed in RP number 25 of 2024. Your Lordship could, my Lord, have the review petition along with this application also. In fact, my Lord, what had happened is, there is no formality. Four of 22, my Lord, on the last occasion when it came up for hearing, the Lordship had indicated that it would be better fit if I filed a review against the order. My Lord, I have filed a review. My Lord, it is numbered in review petition number 25 of 2024. If that could be taken along with this matter, my Lord, could decide. Yes. But the application IF4 of 2022 was filed seeking recall of the final order. Review application? Yes, review petition number 25 of 2024. That will come. So this will not. Lord, if your Lordship could keep this application pending, reason being, my Lord, the review is sought to recall, my Lord, the order. My Lord, what had happened is, my Lord, the writ appeal was disposed of in view of, my Lord, Caparo engineering judgment, holding that, my Lord. So you can urge this ground also in review. Lord, what had happened is, Lord, the writ appeal was disposed of in view of, my Lord, Caparo engineering judgment, saying that, my Lord, appeal against the order passed by the Labour Code, my Lord, against in the writ petition, once it is ordered, my Lord, the writ appeal is not maintainable. In fact, my Lord, subsequently, this Honorable Court had clarified in another matter, saying that it is maintainable in view of the fact that certiorari is sought, my Lord, in the writ petition. My Lord, therefore, your Lordship said this, let this writ appeal IA be pending. That's the argument in this matter. Please, my Lord. In fact, when the matter was listed on the last occasion, your Lordship had said, let this IA in writ appeal be pending. You file a review petition, we'll have it together so that it could be disposed of. Lord, therefore, I filed review petition separately. In fact, my Lord, your Lordship's predecessor, my Lord, in another matter has clarified, saying that writ appeal is maintainable. So review will include recall, but recall may not. Lord, if your Lordship recalls the order, my Lord, my appeal will be restored. That's the only thing, Lord. Because your Lordship had indicated that on an application for recall, we may not restore the matter in view of the fact that it is disposed of. My Lord permitted me to file a review. My Lords could tag review petition along with this, my Lord, so that my Lords could pass a common order. My Lord, because both applications as well as review petition for the same relief, in view of, my Lord, liberty granted by this Honorable Court, my Lord, I filed review petition. On the last occasion, matter was heard at length, and my Lord, your Lordship had indicated that better fit to file review, and then we'll keep this pending till then. When the present application comes up for recall of the order dated 7/6/2022, passed in writ appeal number 74 of 2022 comes up for consideration from a learned advocate, Mr. Pradeep Savkar. I'm his colleague, my Lord. My name is Kashif. Would not dispute the factual position that the applicant herein has already filed a substantive review application in respect of seeking to review the very order dated 7/6/22. Full stop. In that review, this court does not see any good reason to go into the. May I make one submission? Lord, No, my lord, because I had filed this IA, my lord, there was delay in filing the review petition. Because your lordship permitted me to file a review petition, there is delay in filing of review petition. My lord, because if your lordship tags both matters together and takes it, my lord, there will be no requirement for restoring the order again. That's the reason, my lord, I'm requesting your lordship could tag review petition with this writ appeal so that it becomes easier.
What is it? In that view, this recall application is not entertained. Full stop of all the, it is accordingly dismissed. All the contentions for both the sides are open to be raised in the review application.
But I appear the matter seeking review of the order passed by the Sound Court. Lord, in fact, there are certain office objections wherein there is a delay in filing the review petition. Your Lordship, may I ask for a week's time to file an application for filing? And I'll comply with all the office objections. 1 week.
Your original lease expired when?
Pardon?
Will grant time, but
Yes.
your original lease expired in which year, which date?
It has expired. We had filed an application seeking renewal of that application.
Correct one. Which date it expired?
That was, there is a delay in filing that renewal application.
No, not deal. Anyway,
Not yet.
at the request of Learned Swami,
Swami.
Amen. In order to enable him to remove the office objections. Adjourned.
Much it. Much it.
That serial number 2 and 3
Yes.
are arising out of the same order. Lord. There are two office objections in the first matter. The office objections are that, Lord, we have not mentioned 283 days delay in the application. And so far as second objections are concerned, Lord, it is, the prayer is not clear. The limited, not.
Now the judgment or order brought under review had gone to Supreme Court.
Yes, my lord.
Yes,
The Supreme Court has remanded.
Yes, my lord.
demanded so far as. Because his writ petition has been dismissed.
Do not know on what ground it is remanded. It might be the very ground on which you are urging review.
So I have produced the order passed by Honorable Apex Court, my
It
lord.
might be the very ground on which you are urging your review. So then both may be subject to the remand order. Where is the order of Supreme Court?
I have produced in my writ petition, second matter, second review petition, my lords.
I could not get it.
May I make a
Page number 43, my
Submission.
lord.
Page number 49,
43,
43.
Annexure C, my lords.
may I make a submission.
So therefore, your review may not survive. Will survive after this Supreme Court order. What will you urge in this?
Not that's in there.
The last, no, the third one. Third one.
Third one is mine, my lord.
Oh, so
These
after
parties are different, my lords.
Parties are, no, it is same order, isn't it?
No, this is with a reference to an order produced at Annexure B in my RP, my lords. In hearing that Shobha Shetty has not moved the Honorable Apex Court.
There is one more RP. So far as this liberty is concerned, Lord, the petitioner has preferred another RP that is pending before this honorable court.
So both are different, 2 and 3.
Yes,
RPs are different. Issue, the matter in issue is almost one and the same.
For application 336 of 23, you are inclined to issue notice.
not
Or learned, will issue notice in your review. That 15 times penalty in respect of.
yes, Lord.
in a-
The
if,
very same order is sought to be reviewed in the next matter. 2 and 3 are the same. 2 and 3 are same.
May I clarify, my lord?
So both, notice in both.
Please, my lords.
Two, Our learned government advocate Mr. S.S. Mahendra for the review applicant. Notice returnable.
Lord, he accept.
I will accept for respondent in serial number 2, my lord.
Learned advocate Mr. Ravindra Gajanan Kolle
Please, my lords.
accepts the notice on of the respondent. This is the order in seal number 2. Then 3, our learned advocate Mr. Ravindra
Copy has
Gajanan
already
Kolle
been served, my lord.
for the review applicant. Notice to the respondents, returnable, to be heard with RP
Lord,
number.
only one
336.
respondent.
Both to be heard together. Both will be heard together.
Yes.
To be heard with review petition 336 of 23. Learned government advocate Mr. S.S. Mahendra accepts the notice.
Delay, if any, may kindly be
Delay is
controlled
there.
in
Delay
both the matters.
349 days.
Yes,
On that day. On that day we'll consider.
Lord,
Let
in
there
both
be-
the matters, delay is there. In this matter also, my matter also.
In your matter also delay is there.
338, 283 days delay is there.
On that day we'll consider delay.
They may
Notice
be-
in both.
They may be condoned, Lord, since you lost it.
Where is delay application? What is the ground for delay? Give some very. So heard so and so and so in second to learned government pleader, Mr. Mahendra. Notice is accepted by learned advocate Mr. Ravindra Gajanan Kolle for the respondent. Delay of 349 days. 349?
No, the
283,
289.
283 days.
283 days. Occurred in filing the present review application at the instance of state. Is explained in the affidavit. Filed in support of the prayer.
There was intervening assembly election, Lord, between 29/3/2023 to 12/5/2023.
Where is the, which?
Para 5,
Para 5.
Para 5, K number 21.
So some officer was busy in assembly election.
Yes.
The averments in the affidavit, more particularly in paragraph 3 to 5, suggests that the time was consumed in undertaking the administrative procedure. The files traveled through the hierarchy of departments before the final decision could be reached to file the review application. It was also stated that between the period from 29/3/23 to 12/5/23, the officer concerned was authorized in applying support in the assembly elections 2023. This further contributed passage of time to lead to delay to the first extent. Full stop. Since the grounds are administrative, some element of indolence could not be attributed at any point of time or on any officer. Sufficient cause is made out, delay is conduct.
Bless.
So notice in the review application returnable on.
In my matter, my lord, serial number 3, there is a delay of 349 days, my lords. And I have explained by way of an IA at page number 58 of my affidavit, at paragraph number 5 and
Review
6.
application 336/23 and learned Ravindra Gajanan Kolle accepts notice. So this is third. So same order, the delay is explained by the applicant by filing supporting affidavit.
delay on health grounds as
It
well
is
as. on
entirely
pendency of
elaborated
Supreme
that
Court.
the applicant was undergoing the medical treatment.
And
for his
also
ailments, which
pendency of
prevented
Honorable
him
Supreme
from
Court order.
Making the application immediately, which resulted into occurrence of delay. Full stop. In overall view, delay could not be said to be intentional. Furthermore, review application number 336 of 23 is filed by the state. Furthermore, in the review application number 336 of 23 filed by the state, the delay is condoned. In view of all the above, delay deserves to be condoned as sufficient cause is made out. Delay of 349 days in filing the present review application is condoned. And the IA is allowed. The notice in our review application number 463 of 23, returnable to be heard with review petition number 336 of 23, learned government pleader. Mr.
It
Jesus
is
Mahendra.
learned government advocate will be taking the notice for
Sir,
this.
Yes, I accept. Lord, so far as second office objection is concerned, Lord,
Whatever office objections are required to be removed, shall be removed.
there is nothing to be removed, Lord. The office raises a note saying that there is no clarity in the prayer. Prayer is very clear, Lord. All that we sought is,
Copy of Saudi government and copy. All the office objections are dispensed with.